proud of Bill because I am. I would like to introduce to you Maine's Attorney General, Bill Schneider.
Thank you. Thank you. Is that working? Good. Thank you so much, Lois. That was just humbling, and I could tell it was heartfelt. So it's much appreciated. Lois and I go way back. We've worked together in politics for quite a long time, and we served together in the House, and it was just a great experience. I'm represented by Lois right now, and I'm very fortunate to be so. And I'm also represented by Ellie Espling, and I'm proud to be so well represented in the House as well. Thank you, Ellie. I thank you all for having me here tonight, and I wanted to talk about our case and our suit that we brought against the Obamacare law. I thought that it might be useful to give you a bit of a briefing about it, tell you where we stand right now and where we're going to be as we go forward on it. You could be proud of yourselves as Republicans and as politically active Republicans, because this is an area in which every one of you has made a very direct difference. My predecessor, the Attorney General, refused to join the Obamacare suit, and she had several chances to do so. She also stated that she thought it was going to cost the state of Maine something like $400,000 to join the Obamacare suit. And I can tell you, as a matter of fact, that one of my very first priorities upon taking office on January 6th of this year was to find an effective way for Maine to oppose the Obamacare law. Senator Collins told you what a dangerous thing the Obamacare law is, and from a legal perspective, it's every bit as dangerous. We found a way with the Florida lawsuit that had been already filed with 20 states challenging the constitutionality of the Obamacare law. We joined 5 other states and asked Florida to allow us to join their lawsuit, and Florida was enthusiastic, and they welcomed us aboard. So 2 weeks after I took office, we joined the Florida lawsuit challenging Obamacare. The Florida lawsuit was challenging 2 specific parts of the Obamacare law. The first part it was challenging was the individual health insurance mandate, which, if this law is allowed to go into effect, would require every single American to either purchase or to have health insurance that is of a specific, specified nature that the health care law spells out. This would be, if this is found constitutional, it would be the first time that Congress had the power under the Constitution to make every American buy anything. If Congress is allowed to do this, if Congress can make you buy health insurance, then they can make you buy a GM car if GM is suffering. They can make you buy red slacks if the red slack industry is suffering. Their powers virtually are limitless if they can force you to buy this health insurance. So our argument in that area is that this is a power that just doesn't exist to Congress, that the Constitution doesn't give this power to Congress, that the opponents said that the Commerce Clause gives this power to Congress, that Congress has the ability to regulate commerce, interstate commerce. But as I said, if this is found to be amongst Congress's powers, it would completely do away with all of the limitations in the Constitution that apply to the federal government. So that was our first area of challenge for the health care law. The second area of challenge was the Obamacare law tries to force every state to raise its eligibility levels for Medicaid. And this would produce an unbelievably huge fiscal impact on all the states. And it would, in effect, take away the state's ability to make choices in how they're going to regulate their Medicaid health care coverage. And our argument was that that was an unconstitutional application of federal law over the states. We joined the lawsuit at exactly the right time because it had been argued already in the federal district court in Florida. About 2 weeks after we joined the lawsuit, Judge Vinson, the district court judge in Florida, issued his ruling. And it was a very, very strong ruling. We were absolutely thrilled to see the ruling that he issued. He ruled that, indeed, the health care mandate, forcing everybody to buy health insurance, was unconstitutional, is unconstitutional. He ruled against us on our Medicaid argument, but he thought that the severity of the problem with the health care or the health insurance mandate was so severe, and that the law was so complex. As Senator Collins said, it's 2,700 pages of law that has provisions that don't even remotely apply to health care. So Judge Vincent decided that he couldn't take out this requirement to buy health insurance from the rest of the law, and that he wasn't going to go through all 2,700 pages and find out what parts of the law still could stand and what parts couldn't. And normally, when Congress passes a very long, complex law like the health care law, they will put in a clause, a severability clause, that says that if any portion of this law is found unconstitutional, then the rest of it still stands. But Congress decided, the Democrats in Congress decided specifically not to include that kind of a provision. And so Judge Vincent said, with those two factors, he was not going to try to parse through the law, try to decide what could still stand and what couldn't. So he declared the entire Obamacare law unconstitutional, and it was null and void. And so it's very interesting, and I spoke with the governor about this shortly afterwards. After the judge made that ruling, since we were a plaintiff in the suit, the Obamacare law was not in effect, and it was unenforceable in the state of Maine for a period of time. Now, we expected that the federal government would file a stay, a request for a stay, shortly after that. And what that would be is, that would be the federal government asking the judge to say, look, we've got too many things in progress here, the law is kind of rolling along, why don't you just allow the law to stay in effect through the rest of this appeal process, and then if it's found unconstitutional at the end, it'll just die. But they didn't do that. And it's interesting that they didn't, because they were kind of between a rock and a hard place. If they had filed for a stay, they would have been admitting that the judge's ruling affected them and kind of caused the law to be unconstitutional. So they delayed for about 2 or 3 weeks. And finally they filed what they call a motion for clarification, which, who the heck knows what a motion for clarification is? There's no provision in the civil rules for a motion for clarification. But they filed it anyway, and the judge, as we expected he would, he said, I thought my ruling was very clear, but in case there's any doubt in the federal government's mind, I'll condense the 78 pages of opinion that I wrote into about 3, and I'll tell you again what I meant. And so he said that. He laid out again in no uncertain terms that federal insurance mandate is unconstitutional. He said, look, this looks to me like a motion for a stay. Our response to the federal government's motion for clarification was that we said, look, the federal government is actually filing a motion for a stay here, and you ought to treat it like that. And the judge did. So what he said was, I will issue a stay. I'll stay the effect of my ruling, but only for 7 days. And I'm going to force the federal government, if you're going to appeal this, to appeal it within 7 days. Well, the federal government, they had wanted to drag this out as long as they could. And so they weren't at all happy, but their options were foreclosed. So they did file that appeal just last Thursday. And so they appealed it. They appealed the district court judge's opinion to the 11th Circuit Court. Now, we filed a response to their appeal, and in that, it's in our interest, we think, to get this case heard as quickly as possible, to get it heard in the 11th Circuit, and then eventually to get it heard in the U.S. Supreme Court, because that's where it's eventually going to be decided. So we decided as a matter of strategy that we thought that we ought to get this moving as quickly as possible. So in our response to the federal government's appeal motion, we asked that, in fact, the 11th Circuit Court, we asked them to hear it. We asked them to hear it on an expedited basis to move up their schedule faster than they normally would. And in fact, I think they're sitting on June 6th, and we wanted to see if we could get it in front of them on June 6th. And what's more, in a usual appeal to a Circuit Court of Appeals, a 3-judge panel will hear the appeal and then make a decision. And then sometimes you can appeal it within the Circuit Court to what they call an en banc panel, which is all of the judges. So we asked that that the Circuit Court take it directly to the en banc stage to have all the justices review this appeal and to do it on an expedited basis. The court got back to us and they said, indeed, they are going to do it on an expedited basis. I expect that they probably will hear it at their sitting on June 6th. They have not yet decided if they're going to do it en banc or if they'll do it with a 3-judge panel, but it's moving right along. I think it's very clear. It's very clear to me, with all my legal experience, that this provision is unconstitutional. It's also clear to me that Judge Vinson's ruling was correct. That you can't take that requirement for every person to buy health insurance out of the Obamacare law and still have the law have any effect. So if I were going to bet, and I'm not going to bet, because who the heck knows what courts are going to do, but I would bet that Judge Vinson's opinion is upheld in the 11th Circuit, and I would bet that it'll be upheld in the U.S. Supreme Court. And I would bet that the result of that will be that Congress will have to go back to the drawing board. They'll have to come up with a health care reform plan that actually does what it should do by lowering costs and by making health care, improving the health care system. My point with the reporters I've talked to and the folks that I've talked to about why Maine joined the health care suit in the first place was that everybody knows that our health care system is broken and needs to be fixed, but we sure don't want that fix to be built upon an unconstitutional foundation, because that's just a recipe for disaster. So that's why we joined the healthcare lawsuit. That was kind of just a quick down and dirty briefing about how it's been going. And I just want to thank you all for having me here. Thank you very much. Thank you. I got on such a roll with the legal ideas that I forgot to mention the fact that we're going to be able to do this. We joined the lawsuit, and we're going to be able to do it for almost no cost. I expect that it may cost us a few $1,000s because the 26 states that are part of this lawsuit are hoping to hire an expert to help us with the Supreme Court argument. But it may cost us a few, like in the maybe $10,000 to $12,000 range, but it's certainly not going to cost us the $400,000 that my predecessor said it would. So that's